Welcome to the Paradigm Shift on 4ZZZ 102.1, where we challenge the assumptions of our current society to resist oppression and investigate alternative ways of living, for a world based on justice, solidarity and sustainability. Welcome to the Paradigm Shift on 4ZZZ 102.1 FM. My name's Andy and I'll be hanging out with you for the next hour on your radio. I'm coming to you on Jagera and Turrbal country here in Magunjin, Brisbane. And today on the show we are going to be talking about something that happened last week, which was the sentencing of David McBride, military lawyer and whistleblower, whose leaks were the sources of what became known as the Afghan Files, an ABC report on misconduct and issues in the Australian military, which partly led to the Brereton report, which found very significant issues and verifiable claims of war crimes. And that process is still all underway. But the person who was the source of it all, David McBride, last week was sentenced to prison for leaking this information. In fact, 5 years and 8 months of prison. So an incredibly long stint for the act of telling the truth, a truth that it's pretty hard to deny is in the public interest, considering everything that's come out of it since and that will continue to come out of it as the Brereton report sort of is put into practice, and there's been the government body tasked with implementing it, has released a report last week at the same time. And in a shocking irony, while nobody has been tried and only one soldier has been even charged with any crimes committed in Afghanistan, the person whose only crime was to tell the truth about it and let the public know about it has been sentenced to prison. And so we're going to hear all about it. I'll speak with Binoy Kampmark, who is a legal academic, about the significance of this trial, and you'll hear in more detail about it. But my own personal opinion is that this is extremely significant and we should be causing a fuss about it. Any way that we can, we should be showing solidarity with David McBride in prison if we can, and once we work out how to write letters to him and things like that, and we should probably organise solidarity rallies, all these kinds of things. But also we should be really talking about what this verdict means for this country and the kind of society that we want to live in, because this is an injustice done to one person, right, David McBride, and being sent to prison for 5 years is a waste of 5 years of anybody's life, right? We shouldn't support, incarcerating people when it's not in the public safety interest to do so in general, but whose only crime was telling the truth out of a sincere belief that the public need to know the truth. And there has been some sort of discussion about his motivations and that maybe he wasn't as in line with investigating soldiers as it's turned out, the Brereton report has turned out. But to me, that is not relevant to whether he should be in jail or not. For one, you don't police people's political beliefs, right? Whatever people believe, like that is not against the law. But two, he believed it was in the public interest, and it's turned out it has. And that was why he did it. And what we're talking about here is a trial about the public's right to know what happens when, everything that happens in the military, it's not only done paid for by Australian taxpayers, which it is, it should be reminded, it's also done in our name, right? That this is some sort of Australia's projection onto the global scale. And so all these things have happened in our name, and yet we've got a government now saying that we have no right to know what gets done there. To be told through that, then we have no ability to control it, right? You know, if people had known what was going on in Afghanistan, maybe there would have been a greater push by Australians to get troops out of there. Maybe in terms of voting, people would have voted for a party that wasn't so gung-ho on going to war. All these kinds of things that supposedly keep our democracy functioning. That this trial says that we never should have known any of that. And there's so much secrecy when it comes to military, and as we'll hear in this trial, there was so much secrecy around this trial as well, around what evidence could be used and things like that. And so on trial here is not just David McBride, it's also the public's right to know the truth and to act on it, but also it is about the right of individual conscience, because part of this court case was about whether David McBride had any right, whether he has any legal defence to say, well, I acted in what I believed was good, or whether you just have to follow orders. And it's kind of shocking, but the court ruled twice, not once, but twice, the appeal court as well, ruled that if you are a soldier, it is your job to obey orders and nothing else. The public interest does not come into it. What implications this has for the kind of society we want to live in and how we want our armed forces to behave is pretty scary, you know. And we've been there before. Binoy Kampmark, who I interview later on, references the Nuremberg trial, which is an obvious comparison, where person after person got up saying, well, I did what I was told to do, and an international court said, that's not good enough. It's not how we're going to make a worthwhile planet to live in if people just do what they're told to do. You've got an individual conscience and you have to use it. Well, according to Australian courts, you don't. You don't have an individual conscience and you don't have to use it. In fact, you're meant to push it aside. And it's very, very concerning. And I guess for accountability of all government bodies as well, right, you need to encourage people to do the right thing, and that when there's the wrong thing being done, to step in and do something about it. And instead, we've done the exact opposite here. And so, yes, for all these reasons, the sentencing of David McBride is a severe concern for all of us, and it won't be the last you hear about it today on the Paradigm Shift, although we won't be seeing David back on the outside for quite some time. Of course, there will be an appeal coming, and hopefully that will be a better result, but I think we need to keep on acting on this, and we need to keep remembering David McBride, and also keep remembering the injustice that's been done to all of us in that ACT court last week. So we'll hear more about it on the show from Binoy Kampmark in a minute. In the second half of the show, we'll hear a bit about another trial of an Australian charged with telling the truth, Julian Assange. We'll get an update there from John Shipton, his father, and there's been a little bit of good news in that case. But to start off with on the show, let's hear from David McBride himself. Fortunately, it wasn't entirely unexpected for him going to prison, and so he's probably done some preparation for it, including making this video, which he posted online with the title, "If You're Seeing This, I'm in Jail."
If you're watching this, I'm in prison. Again, all I can do is thank the supporters. I'm not going to complain. I went into this with my eyes open. I always said I would go to prison with my head held up high, and it may be that I need to go to prison in order to fix this country. We need to look at how this country can pretend that I'm a national security threat when there are so many other things wrong with it. So much bribery, so much corruption, even war criminals that haven't been in jail, and leaders of our completely failed war effort, 20 years, $6 trillion, 41 Australians, good Australian soldiers dead, and no one has had to answer for it except for me, because I have damaged national security. I will sit in jail, I will get stronger in jail, we will build our forces. Plenty of people down through the ages have been in jail and have come out stronger, so don't worry about me. maybe if you can, if you know my family, if you know my team, extend a helping hand, extend some love to my family. It won't be that easy for my girls, but they're strong girls. And when I tried to explain to them, or my ex-wife Sarah did, to say, you understand Dad might be going to jail, they were like, yippee-ki-yay, motherfucker, which I just love. They're not scared. They're a chip off the old block, and they are proud of me to not go silent until I'm out. I believe we'll win on an appeal. I believe the High Court will eventually have to say that we can't put people in jail for doing their jobs. I was a military lawyer. What do you think my job would be if not to pick up on potential illegal activity within the organisation that I was meant to police? I did my job, put me in jail. My head will be held up high. I may have been a bit emotional when I was sentenced, but I can assure you, once the dust has settled and the exhaustion is gone, I will look back on this and be so grateful to everybody who supported it. Anyone who supported me, don't think this is a failure, this is a victory. We're going to win this, and when we do finally win it, it will be so fucking sweet.
David McBride, who's currently sitting in a prison cell and may be there for quite some time. He was sentenced to 5 years and 8 months in prison for leaking to the public classified military documents. A little video he made in preparation for going to jail. If you do want to hear more of him, I did have David in the studio here on the Paradigm Shift in the middle of last year, and you can find that one on the Paradigm Shift podcast if you use a podcast app. Have a search for Paradigm Shift on 4ZZZ and David McBride, and you can have a listen to a long chat that I had with him. But for now, we are going to speak to Binoy Kampmark, who is a legal academic who has been closely following this trial, and me and Binoy dig into what on earth happened in that ACT court late last year, and what does it mean for all of us.
My name is Dr. Binoy Kampmark. I do in several capacities academic at RMIT University, but I lecturing in human rights, for example. But I'm also a columnist for the Mandarin in Australia, but also a contributing editor to Counterpunch in the United States.
And today we're going to be talking about the sentencing of David McBride, which happened last week. And so many people will be aware in some ways of the background of David McBride leaking materials that became the basis of the Afghan files. But could you give us a bit of an intro to the case against him legally and why it's significant?
Yes, so David McBride took 235 documents from defense offices primarily located in the ACT, and these particular documents covered, as it were, actions, disagreements, pursuits, if you like, of various individuals in the special forces in the Australian Army, the Australian Defence Forces. And the important thing about these documents was revealing, as it were, a certain pattern taking place, a culture of abuse and a culture of also mismanagement, and also a culture of, in some cases, false investigations, and in other cases, non-investigation, and essentially exoneration of the higher-ups, if you like. So McBride had various reasons to do so. He didn't quite necessarily have the original reasons that ended up becoming the basis of the revelation, but at the same time he was a very vital figure, as it were, in the context of exposing misconduct on the part of the special services in Afghanistan. And
so this happened a long time ago. It was, 2017 that happened. And so it's been a long legal process that's come to a conclusion, probably not the final conclusion. But so I guess the trial itself, besides the matters that he's leaked, the trial itself is of interest to people who are concerned about truth and justice and democracy in our society. And so there's a few elements of the trial that I think are worth talking about. And I guess to start off with, let's start with the idea of a whistleblower defence, that Australia has these public interest disclosure laws that could have been used to exonerate David McBride and weren't used. What's the significance of this?
Well, it's very significant because the Public Interest Disclosure Act, which is the primary whistleblower provision, is a fairly toothless document when it comes to its application, and the reason for that lies in several things. Firstly, it's very vague, and secondly, it's very cumbersome. When McBride tried to make use of this, he made an application to use it last year. It was essentially a hopeless task because the Commonwealth decided or threatened to withhold documents on the basis of what's called public interest immunity, which is a very long-winded way of saying privilege, crown privilege essentially, which means that on security grounds he would not be able to use documents that would exonerate him and justify, as it were, the public interest. So the Public Interest Disclosure Act was shown to be a fairly toothless sort of instrument, and despite reforms proposed by the Albanese government, or at least promises to reform, most of the reforms to the whistleblower aspect of this have been of a cosmetic variety. We simply don't have any kind of heft to the instrument the way it is. And certainly McBride had very little to go on when it came to those defences.
And so that was a severe blow to his planned defence in this trial. Another thing that happened is that the government actually seized some of the documents that he was planning on using as evidence in his defence, and under the idea that they were to do with national security, they seized these documents, and so in the court of law he couldn't defend himself. I mean, what's the implications of this?
Well, the implications of it is that you have an unfair trial. So what happens is that you accuse someone of having pilfered documents, and then you accuse them of having committed various breaches of national security laws, but then you don't enable that person to use the very same things that supposedly he had pilfered. So it is a very strange set of circumstances, and it also meant, and that was the critical issue, it meant that his legal team essentially decided on the basis of that to plead guilty. So they reduced, there were 5 charges initially, and then they were reduced to 3, and he pled guilty to those particular 3 charges, and that was the outcome of that.
So the other element of the trial that is really interesting for us is about his defence, about saying that he had a duty beyond the lawful duty to obey orders. He had a duty to serve the public as a soldier. And the court rejected this line of reasoning, which certainly seems to be very worrying for anybody who knows the history, both recent and long ago, of soldiers and orders and things like that. What's the significance of this?
Well, it's very significant. It came as a surprise to me, essentially, that in Australian military law, but certainly in the application in the context of the Australian Defence Forces, they haven't heard of a particular famous trial known as the Nuremberg trials of 1945-46, which is extraordinary, because in that particular trial, which is the trial of Nazi commanders, officials, generals, and so forth, it was famously laid down, as it were, that the idea of superior orders, or orders, there's certain orders, as it were, that you should not follow, and there are certain duties of obedience by which you actually should qualify. Is this, for example, if there is an order, there's something to commit crimes, you avoid it. You don't do it. There's a duty, as it were, to not pursue that line. Likewise, in virtually every international statute, or the Rome Statute, which governs the ICC, the International Criminal Court, international law acknowledges the fact that you should not follow a particular course of action as a military officer or as a member of the military in certain cases. According to the prosecution, that's not the case. So the prosecution of McBride was based on the idea of 19th century authorities saying that the duty is absolute. The duty to follow the sovereign is absolute, which is astonishing. And there is no public interest to be assumed in that pursuit, because if there was, then there would be anarchy in the forces. There would be absolute loss of control. So this is essentially the gist of it. It was an astonishing thing to read, and astonishing also that the lawyers there for the prosecution could even concede that point or pursue that point, and also that Justice Mossop didn't have a problem with that. Likewise, the ACT Court of Appeal, because this point was initially raised as a potential issue.
Yeah, and in the context of the disclosures made by David McBride, this is really extraordinary as well, because we're talking about something that even the Defence Forces admitted is, illegal actions, war crimes, and that there was a culture in the military that encouraged this. And then on the other hand, there's this thing now saying, well, you can't disobey orders. If you're told to do something, you have to follow it. And so it's like, well, how do we then build a better culture than what we've seen with the SAS troops in Afghanistan?
Well, precisely. The key problem or the key issue here is that, and this really was the thrust of the prosecution, it really didn't matter what McBride revealed, insofar as, it had good consequences, exposing, as it were, criminality. The issue was the very fact that he did it, and the very fact that it was illegal, harmed, as it were, national security, and harmed, as it were, the broader standing of Australia, or the broader standing of its reputation in an international sense. So it is deeply troubling in so many ways in terms of how the nature of whistleblowing works, because he was really hung out to dry in this context.
There's one other thing. The sentencing was delayed, actually, from when it was initially meant to happen, I think in March, because there was other evidence that was withheld by the prosecution that the defence said should have been submitted and would have affected the trial. What's the story with that?
Well, yes, I was also a bit perplexed by that too, and I think it's going to be the subject, I hope, of the appeal, that there was this delay. But a lot of the reasons for this probably arise from the fact that the prosecution, namely in this case the Commonwealth, have absolute, impunity when it comes to adducing evidence, withholding evidence, conveniently adducing it when it suits the purposes and so on. And so this is going to be sort of the interesting thing I hope will come out in the appeal. But when it comes down to it, national security cases like this are very hard on the individual who's accused, as we've seen. The same thing with Bernard Colliery, the same thing with individuals in the security services, the witness K, and so on. It's a very difficult thing when the national security element is used, because you don't know what's going to come at you next. So the delays were probably occasioned by, again, that expedient nature by which they were behaving.
Well, last week he was eventually sentenced, and the sentence was 5 years and 8 months in prison with a non-parole period of 2 years and 3 months. It's quite a severe sentence. It's more than you would get for many violent crimes. Was it a shock, the severity of the sentence?
Yes, it was. It was a shock, because there was a general assumption that he would get, the parole period would be the period that he was expected to get as the sentence, about 2 years, and in some cases maybe custodial and so on. But he was given essentially the full whack, which was just brutal. It was absolutely brutal, and I think you could see that the reasoning by Justice Mossop was, and this is also an odd thing, the reasoning was based on giving the full maximum punishment essentially in the context of this, because it's meant to be a deterrent. And he made no bones about it. The judge was very clear that this was meant to deter future behavior of this sort. And then secondly, and this is the strange thing, he said even though McBride damaged it was damaging in terms of his disclosures, be it to national security, be it to reputation, and so on. There was actually no evidence adduced by the prosecution, and no evidence in terms of any investigation that there was actual harm. So we have a very curious sort of way where the very act, as it were, of disclosing these documents, the very fact that McBride did so was what was significant. It's not that it harmed anyone at all. If anything, quite the opposite. It actually disclosed criminality that needed to be addressed. But the fact that he disclosed it is the very fact that he was punished, and that was very evident in the reasoning of Justice Mossad.
And the deterrent there, obviously, is to suggest that anybody else who wants to release uncomfortable truths should be deterred from doing it, which is maybe not what many of us in our society hope is the message that gets sent out from our justice system.
No, it's not, but I think it's very much a case of what the authorities on the one hand do and claim they do, and then what actually happens. So we've got this, and let's not forget, your listeners should not forget as well, that all through this process the Attorney General could have intervened. Mark Dreyfus could have intervened using powers available to him to drop the case, but he refused to. He did in the case of Colliery, he did actually intervene on that point, but for some reason, and I'm sure the reason is that precisely because it was a military matter and it's close to the security forces, he decided not to intervene on this point because the circumstances have to be exceptional. Well, I regarded the case with McBride as exceptional, but it would seem that, and I think that's precisely because he's a former military, a lawyer involved in the military, he's attuned to the system, he's part of the armed forces, and you don't want the armed forces starting to get funny ideas about conscience and morality if you want them to go to war. So I think it's a very sad nature that essentially the whistleblowing aspect has been totally blunted in this regard.
Yeah, so I mean, this is undoubtedly a political trial, and it's has consequences on the culture of our military and the culture of whistleblowing in this country, and I guess truth in general, and truth as a part of the discourse of our society and how important it is. What do you think is the political significance of this trial?
Well, it is very significant because when it comes down to it, the political dimension, as you say, is very hard to avoid because ultimately the reason why people go to war, and the reason why individuals such as McBride and also his colleagues and his peers and those in the Australian military, the reason why they find themselves in war is because decision makers send them there. And the ultimate thing, and then the big story that's always missing in this, is that someone like McBride gets punished. Individuals in the armed forces who have either committed the atrocities get away with it, and if not, the commanders get away with it, and even worse, those sending those individuals into harm's way get away with it. Because ultimately, the reason why they're there is because the public policy wonks and the politicians in Canberra send them there. Stupid reasons, foolish reasons, often misguided, often ignorant, and they get away with it as well. So ultimately, yes, this is a political trial of significance. It's a very dark episode, as it were, in the broader context, not just the whistleblowing laws, but the broader context of Australia's role, as it were, in wars. And I think this is something that will come through in the course of our discussions about this case in the forthcoming years.
All right, thanks very much, Binoy, for chatting with us today.
Andy, anytime. Thank you.
Here are on 4ZZZ, The Paradigm Shift is the show. We're talking to Binoy Kampmark about the sentencing of David McBride to over 5 years in prison. I promise it will not be the last time we hear about David McBride on The Paradigm Shift. I'm committing right now to supporting this person who's been sent to prison literally for nothing other than telling the truth, revealing the truth about what happened and believing that the public should have a right to know. And it's not the kind of world that I want to live in when that's the case, when people are going to jail for that. And so it demands all of our solidarity. And that comes in lots of ways. I think we should have an ongoing campaign to remember David McBride and make sure the public remembers. And also, when we get the address, to write letters to David McBride and things like that, to continue to do that, to make sure he's not forgotten in there, and knows that people are out there thinking of him and appreciating what he's done. And also, we should all tell the truth. Get out there, tell uncomfortable truths fearlessly, to try to create more a world where it's possible to do that. And, for some people, there's a lot stronger consequences for that than others, but all of us, it's about, if this is what we believe in, let's go out and do it. And I think, the best way to counter a world of sort of deception and cover-ups is to try to find the truth wherever it is and boldly proclaim it. So let's do it, not just for David McBride, but for all of us. Because, how else do we get to a world if we can't even understand what's happening in the world today? Somebody else who's in a lot of trouble for telling the truth is Julian Assange. He has been in one form of detention or another for 13 years now, and he had a bit of a win this week in court. It's not a huge win. He's still in prison and he's still facing extradition, but he will have the right to appeal his extradition to the United States. The UK High Court granted that they had a right to appeal on the basis that the US couldn't guarantee Julian Assange's freedom of expression if he was extradited there, which he has the rights to. All European courts have a necessity to protect the freedom of expression, and that because in the US they're supposedly a universal Bill of Rights, us with all men are created equal, it doesn't actually protect people who aren't US citizens in their courts. You don't get those Bill of Rights protections, and so Julian Assange would not necessarily have that constitutionally guaranteed freedom of expression in the US, and so the court case will go to another appeal, and hopefully there'll be a good result. Until then, Julian remains in Belmarsh prison, and really the solution will have to be a political one. The court cases, by the time they're finished, there might not be much left of Julian Assange. We need a political campaign to get him out, and it seemed like there's been some gains since the Australian government under Albanese has come out more in support of Julian Assange. John Jiggins, friend of the Paradigm Shift and long-time community radio reporter, spoke to John Shipton, who is the father of Julian Assange and one of his long-time supporters, and we do appreciate John Jiggins sending us this story, and I hope you're doing well. Johnny had a bit of a health scare, but good to see he's still out there fighting the good fight, and he started off by asking what John thought of the court proceedings and the High Court decision.
The decision is good news, for us. In the court, there were 2 US Marshals. There was also a car with US Marshals in it. If the decision had gone the other way, Julian would be taken and put on a plane to the United States. So for us, it was a moment of joy and relief. In the court hearing, it was extraordinary to see the United States representative prosecutor trying to suck a golf ball up a garden hose, the allusion to the effort that he was putting in to the impossibility of justifying a assurance that the United States would allow Julian to have a hearing to apply for the protection of the First Amendment free speech legislation in the United States. In Europe, in the UK, they have a similar clause to the First Amendment of the United States Constitution. It's called Article 10 of the European human rights legislation. It also covers free speech. So Julian found benefit from that. And so the appeal hearing can deliver itself to judging whether Julian would be able to receive the benefits of Article 10 legislation in the United States if he was extradited. Also demonstrated in the Supreme Court of the United States that he wouldn't receive protection.
Stella, Julian's wife, tweeted she was very relieved with the decision, and you were too, obviously. But this is not the end of the matter. The US has been given another chance to give these assurances, and you'll be back in court again, won't you?
Well, maybe further hearings. The speculation is that the United States Department of Justice doesn't want a hearing in the United States over a First Amendment matter before the election. That's what people say. From my point of view, and I say this with all the firmness I can possibly gather, that since the involvement of the Australian government in the matter of Julian Assange's prosecution and persecution, it's become a state-to-state matter. State-to-state relationships, particularly between friendly states or associated states like the United States, the United Kingdom and Australia, and the involvement of Australia in AUKUS. The matter has changed its character and complexity altogether. Now, the demeanour of the court in the last two hearings since the Australian government's made its concerns available has completely changed, and the good manners and provision of seating and careful consideration of Julian's lawyers and supporters is altogether different, fundamentally different. So we all must keep firmly in mind that it's the supporters generating an upwelling of enthusiasm for Julian's fair treatment that has brought into being a political circumstance that the Australian government has to address.
It's been quite a burden on you, your family, and Julian. How much has it cost, for example, just to have all these court appeals which you've had to sort of sit through?
I don't know, many tens of millions. There was an article written by Declan Hayes some time ago, which estimated that the supporters worldwide since 2016 have spent about $100 million on Julian's defence. For us, we just spend everything. I mean, houses go, savings are gone. And we exist upon politically the support of our supporters and financially the support of supporters. We rest upon the shoulders of the supporters worldwide and in particular Australia. I've got to say that so firmly. Without the support of the Australian people and the now Parliament and the government and the delegations that travelled to the United States, the delegation of parliamentarians that travelled to the United States, Julian would be extradited to the United States and Australia's sovereignty would have suffered a severe blow.
Jen Robinson refers to this as a process of torture.
They use the phrase punishment by process. And of course, the process is the legal process. It just goes on and on for now nearly 15 years. The United Nations Rapporteur on Torture, Professor Nils Melzer, he goes at it even firmer and harder, which I agree with. And he says that it's psychological torture, constant smearing, never knowing where things are going to end, never knowing when the next court case is going to happen, never knowing if you've got enough money to pay the lawyers and so on. In that sense, it's sadistic. And I feel after so many years, it's obvious to many people that sadism and maliciousness is on behalf of the United Kingdom Crown Prosecuting Service and the Department of Justice in the United States. That malicious sadism can only be consciously deliberate by the bureaucrats that inhabit those institutions.
That is John Shipton there, father and supporter of Julian Assange, who will be heading to court again to appeal against his extradition to the United States, where he will face charges that will sentence him, if found guilty, to certainly the rest of his life in prison, again, just for telling the truth. And again, all of us who believe in the truth, our right to know the truth, or our right to speak the truth, should be supporting Julian Assange, considering that's what's on trial here, not just one person, but the truth in general. So, yeah, we'll keep going, and both of them are acting in a long tradition of whistleblowers and courageous truth tellers, some of whom, got much worse penalties over the years than Julian Assange and David McBride have been faced, as to be said, but some of whom have been victorious in fighting against the systems that aim to cover up the truth. And it has been great, actually, with David McBride to see that there's a group of whistleblowers from Australia across the country, from things like the Commonwealth Bank and Clubs New South Wales, and now Richard Boyle in the tax office, getting together to support David McBride and show solidarity. And that is great to see, and it is so important. Yeah, as I said before, I invite all of you not just to support those who do that and are suffering the punishment, but to be part of the people who tell truth even when powerful forces are trying to cover them up. We'll be back next week on Paradigm Shift, and I'll see you then.